Dr. Dominic Aquila, your biosketch at New Geneva Theological Seminary says you've been a Presbyterian pastor for 3 decades, president of New Geneva, the editor of the PCA's online newsletter, the 2006 moderator of the PCA, a professor at least 3 different seminaries, and you lost count after that, and a board member of numerous ministries. I also know that you were a Christian college president and a founding member of the PCA Standing Judicial Commission and chairman for several years, where you and I jointly served for several terms. I also know we've done 3 lectures on the subject of the BCO for Dummies at First Presbyterian Church, North Point, Florida. I've listened to some of those and would observe that Lecture 2, for example, has to do with vignettes from your vast practice counseling parties involved in church discipline matters, and sometimes ghostwriting letters, complaints, and appeals for these parties. The one in particular involving what I would call violations of due process against a wife who was being abused by her husband, and our session sanctioned her for separating from her husband without biblical grounds for divorce in the sessions with a long list of failure to follow the proper steps in church discipline. So welcome to my series on church discipline for dummies, similar to yours, in which I'd like you to comment on aspects of BCO 31-2. Specifically, there's a widely held belief throughout the PCA that if a session or a presbytery commission gets a complaint from an outsider, labeled charges, that obviates their duty to investigate and that they're obligated to initiate process. And I was wondering what your take on that is.
Good. It's good to be with you on this Church Discipline for Dummies. I think it's a great title. I love it. The 31-2 is a very important part of the Book of Church Order because it is the starting place. And so we have to
church discipline matters.
Church discipline matters, and it has to. First of all, we need to correct a few things. That charges can only be made by the court. That is only the session. So you correct even the way you ask the question. What people do are, from any source, can have allegations. They can attribute certain things to people, but they don't present charges. So the way 31-2 is divided, there are 2 paragraphs. And the intent of that, the first paragraph, is that a member, whether it's a member of the local church or whether it's a minister of a presbytery, the court that has responsibility for that member or minister receives allegations. They are then required to at least look at that and have some kind of discussion with the member. No matter what the individual, whatever word they use, if they say, I have charges against them, that's not what it is, because an individual can't present charges, they can present allegations.
Now this is called the investigation.
That's not yet. The investigation comes in the second paragraph.
Oh, so this first process.
That's right. The first paragraph is pastoral.
Okay, pastoral.
It's a pastoral thing where it says that when the court having that responsibility, the session or the presbytery, will then shall demand from the member a satisfactory explanation. In other words, this is an opportunity to say, so-and-so has made a statement about you. There's a concern that you've done something wrong, you've said something wrong, and they see it as something that is possibly a sinful thing or an offense, and they want us to deal with it. And so they brought it to our attention. Our first responsibility as the session or the presbytery with charges responsibility over you is to ask you, what do you say about it? And we want to discuss it with you, and it'll be on a pastoral level. So there are no charges on the table. Nothing is being looked at in that regard, with the hope that we can resolve the matter in some fashion. So if it is a problem, we want to confront it, we want to deal with it, we want to suggest things to you, and there'll be a pastoral level to it. However, if the member is not forthcoming, or if the allegation is of a serious nature, that the session or the presbytery chooses then to say we need to take this more to a judicial process, then the second paragraph deals with an investigation. Now, the investigation, the book church order doesn't stipulate the how, where, and so forth of it, but it's to be focused on gathering evidence to determine whether or not their formal charges might be able to be presented against a member given the allegations. So the focus there is on evidence, and a lot of times we forget that because the closer we are to a situation, the more personally invested we are as either elders in a local session or elders in a Presbyterian Judicial Commission. Sometimes we get emotionally involved, and so we hear something and we, gasp because of the nature of it, and rightly so, because we're concerned that it not be an egregious matter. The second paragraph.
The investigation.
It deals with investigation. So if there isn't a satisfactory explanation, the court can move to an investigation. And the investigation is focused on...
If there's a satisfactory explanation...
Then, I'm sorry, that's good point. If
they
there's
wouldn't pursue it.
Then it can be dismissed.
Right.
If the satisfactory explanation. Now, if it's satisfactory, but there are some ramifications, the session may want to then enter into a discussion with this member about proper remedies. That may
formal investigation.
That could be a formal explanation, or the person may realize that he or she did something that was out of order and that needs to be confronted because of its seriousness, and the session would weigh the relative seriousness of the matter. Okay. And if it is serious, then they can, and the member acknowledges that, and they feel that something should be done, then we could take a case without process and go to BCO 38-1.
And that's if they admit it, right?
That's right. If they admit it, then they make a confession, they approve that confession, the court approves it, and then the court deals accordingly without there being any kind of process, and then the matter is resolved because the issue has been confronted and everybody has agreed to it. But if the person is being with the demand of a satisfactory explanation does not respond well, and the court is of the mind to say there's still something not good here, we'll investigate. Let's see if there is evidence. Now, there may not be evidence. Okay,
so this is if the guy won't plead guilty.
That's right. Well, first of all, there's no guilt yet. Investigation is not part of the judicial process. If there is a sufficient amount of guilt, then the book says if there's to show if there's enough evidence to raise a strong presumption of guilt, then the court shall institute process. So process.
Now, can I ask you a question about that part? This is a sub question I have here about this term, substantial presumption of guilt.
Yeah. Strong presumption.
Strong presumption of guilt. Okay. Now, as a lawyer and a judge, I've had some experience in the criminal proceedings where we have something called probable cause.
Right.
That part out. And it occurred to me that this is analogous to our finding of strong presumption of guilt. And you agree with that?
I agree. In fact, I sometimes say that the grand jury phase, what's comparable to the executive system of the grand jury, is exactly what the investigation is. The investigation is like a district attorney bringing evidence to, or gathering data, bringing it to a grand jury, and letting the grand jury determine whether or not what has been gathered together does show a strong presumption. In our case, strong presumption. In the case of a civil, would be probable cause.
Okay. Second sub-question or sub-question about this term we have, strong presumption of guilt. Does that raise a problem in trying to explain to newbies in our church system? We're not presuming he's guilty by that, are we?
No, exactly not. That's the whole point, is that during the whole process, first of all, you conduct an investigation because you sense there's something wrong, but that's a feeling, and that's not good. So the second paragraph of 31.2 points you to seeking to find evidence, whether or not. And so the evidence would be this. Let's jump over to BCO 35 for a moment in terms of what, if you go to a trial, what is required. 35.3 says that you have to have at least two witnesses. And the two witnesses are defined for us in 35.3 as being two persons who are able to speak to the same matter, or one person and some corroborating evidence, a recording, a receipt, a photograph, or something of that nature. that would corroborate what a person is saying. That's the minimum. So if you only have one thing, one person, or one piece of evidence that can't be corroborated, then that you do not have sufficient evidence. So there's one way of looking at that. The other thing that happens here is when they're doing the investigation, that the person who is the object of the investigation, who has already been called in once for
The pastoral thing.
yeah, right, to the pastoral level to give a demand for the court to demand a satisfactory explanation. If at that point that person, that member, says, you know what, I really think that you're barking up the wrong tree. I don't think I'm guilty here, and so I'm not going to. You can demand it, but I'm not going to give it. That's which then causes the court to say, okay, we're going to investigate. Once that happens, we have pretty much in that provision something like you do not have to participate with the court and the investigation in them trying to find the evidence against you. Okay, now we jump over to 35.1 when it comes to this. 35.1 is saying that no one can be compelled to testify against himself. So if you can't be compelled in the course of a trial to testify against yourself, that means during the investigative stage, if it should happen, then the evidence has to be developed by the court without any assistance from the person, and you can't force them to do that. And the reason I say that is, unfortunately, many times the court will get overwhelmed exasperated, right, that's a better word, by the person. You're not participating with us, so that must prove you're guilty. You know, no, you can't do that. But that happens. The closer we are in proximity to an event and to the circumstances, the more personal and emotional it is. And that's the reason we have to be very careful in trying to be as objective as possible and look for evidence that really mounts, that does it. So you can't, if you start the investigation, you can't expect that the individual is the object of the investigation is required to participate with you in that process as a court. You have to develop the evidence alone, and notice what it says. The evidence must then demonstrate a strong presumption of guilt. Not the person, not your feelings, but the evidence. So if you don't have the evidence, you have to dismiss, you have to put aside, and you can't bring it forward. If the evidence is there, so that, and what's a strong presumption of guilt? I think this definition is very helpful to me. A strong presumption of guilt is evidence that is of such a nature and such weight that if we go to trial, there's a high probability of securing a guilty verdict. You have to, that's the bar that you have to meet. So you've got to have facts. So when you move into the investigation, you're looking for your Joe Friday. Just the facts, ma'am, just the facts.
Right.
It's not my third grandmother or cousin down the way thought about this, or I felt it, or somebody just senses that something's not right. No, we're now moved into the objective distinction. If I may, just let me back off one more thing. I'd like to start by pointing to VCO 3.2, in which it outlines that there are two distinct powers that the courts have. There's the power which is pastoral, which is basically very broad. It's the power of order, and it means that you can love on them, you can shake your finger in their face, and so forth. As pastors, in other words, there's a wide berth that you can take, and that's a form of discipline in the sense of pastoral care, where you're entreating, you're urging, you're inviting, and all that kind of stuff. All right. So that's the power of order. So and in that you're hoping that you can bring a person to his senses about what you believe may be in order, that they will agree with you that there's something. Because by the way, as you and I have talked about this, not everything that we do is necessarily chargeable.
Right.
Okay? Because as you and I have talked and joked about this, that if stupidity was chargeable, we'd all be under charges, right? Sometimes we just do dumb things.
Yes.
Well, and I may have stepped out of line, it's rude, but you don't bring charges against every single kind of thing. There are other remedies that can be found. So pastoral gives you a wide berth. That's the jurisdiction, the power of order. The second is judicial, which is the power of jurisdiction. And this is BCO 3.2. And in that case, now the terms of the engagement change. Now you have a level playing field. You have goalposts at the end of each side, and those goalposts are cemented 20 feet down in concrete. They do not move. It's objective. Okay, and there's like a football game. You've got the stripes on the field, and you follow the rules, and the rules are the same for the court and the same for the member, so that everyone has the same guarantee of judicial process. The justice and equity will be done. Okay?
All right, now, at the point where the investigation results in either a finding of substantial presumption of guilt or serious
Strong presumption.
Strong presumption of guilt. I always want to say substantial for some reason. Strong presumption of guilt or not. If there's no finding of strong presumption of guilt, then what does the court do? Just notify the
It's over. It's
the person who charged the person, or the person who notified you,
right,
or made the allegations.
Raised the allegations, right?
You notify them that they were not found legitimate.
Right.
That's it.
Right.
And you excuse the respondent and say you're in good standing, no problems. All right. Then what about the other way? If it goes that there is a finding of strong presumption of guilt,
What happens?
that's when you initiate process.
That's when it says in the script in the BCO 32, the second paragraph. Then you institute process. Process is then instituted.
And what all is included in initiation of process?
Okay. And at that point, then you have the evidence that points to this, that now you can call charges, and you have to develop what those charges are, and you appoint a prosecutor, and then after the prosecutor most likely will put together an indictment that will level the charges, and then you will then cite the member to appear, and that citation.
Before you get there, doesn't the indictment have to be signed by the moderator of the commission?
Either the moderator or the clerk, either one of the court, whoever the court, whether it's the whole court or the. But let me just say that takes you over to chapter 32, 32:4. Let me. This is an important part that we miss out on. That then in the appendix you have a general outline. That's a guideline for how the charges should be presented, how the indictment should be drafted.
Look like.
Right, and it's just a suggestion. It's not part of the Constitution, but it is good, and it has two parts. There are the charges, and then the specifications.
And then list of witnesses.
That's right. The charges are a charge is something that is generic, general. For instance, someone is accused of violating the 8th commandment. That is, you shall not steal, because someone is saying they dipped in the till and they took something that wasn't theirs, or something that would belong to somebody else. So you would have enough evidence to say, okay, we're charging you with violating the 8th commandment, that you shall not steal. Specifications: on or about such and such a date, you were observed dipping in the till, taking funds. And that's specification 1. Maybe another specification is we saw you put it in your pocket, or put it in your backpack, or something like that. And witnesses to that will be so and so and so and so. The point about this is this: the charge is always very general, but you must have specifications. Specifications are very tangible. They're factual. And the witnesses must be eyewitnesses. In other words, if I observe something and I then become a witness because I'm a first-hand eyewitness, I saw you do something, and then I saw you do it, or I took a video of it, so there's your second witness, and you did that. Then that first testimony, the first person I witness is eligible to be a witness. Now, if I go home and tell my wife I was at the store, I was at the church, or wherever, and I saw a person dip in the till, and not only did I see it, but I recorded it, then my wife, having heard it from me in a contemporaneous manner right away, she is not a witness, so she can't be called because she didn't observe it. Only I could be useful in that. and there always have to be at least two people, because one is he said, she said kind of thing, which
What if you died in the meantime?
if it didn't have,
Could they present the video and your wife's testimony?
No, not in our case. Because it requires that hearsay evidence, and that's hearsay because you're removed from the process. All right, so I just wanted to focus on that because that's another big mistake in the process of doing church discipline. That in the investigation, first of all, you focus on getting evidence, hardcore data, tangible stuff, datable stuff, concrete. Then, if there is sufficient evidence to raise that presumption, it is presumption, so you're still innocent till proven guilty. Then,
So it's a rebuttable presumption.
Exactly, it's very rebuttable, absolutely, because the member will have opportunity once you put it in the indictment to plead guilty or not guilty. If you plead not guilty, then you have the right to a trial and to mount your defense, and to call witnesses that on your own side as well. So, but I just wanted to focus on the charges and specifications. The reason I say that, just recently dealing with the circumstance coming out of a presbytery in which they brought a number of charges against one of the ministers of the presbytery based on the allegations raised by some former members. Okay, and I want to say former because I want to come back and make one more point about that. And who claimed to be witnesses of whatever the generic charges were. And the indictment had not one single specification. When did it happen? Who saw it happen? What were the circumstances? Time, dates, places, circumstances. Do you need that evidence? It wasn't there. I said, so it was a faultily, incorrectly drawn or drafted indictment. You can't prosecute it. It is out of order. Okay? So we raised that before the court, and then they went and found some dates, and they just threw things in there, but they were, again, very broad. They just had years. Well, wait a minute, no. Did it happen on or about the 1st of August, maybe through the 3rd of August or something like that? No, you can't just say in 2019, this happened. When is 2019?
So a vague indictment is subject to a motion for greater specificity.
Absolutely.
And then if there's problems with the specificity, then you can make another motion to make it clarify further.
Absolutely.
And if you don't, do you waive all that?
If you don't, yeah. Well, yes. You may not waive it if the court keeps saying no.
Well,
you go forward.
Let me ask this way. Let's say you make one motion for specificity, and they come back with more vagueness, but you don't object again. Can you raise that with the presbytery?
You can still raise it. You can still raise it later, because what you can say, these guys aren't getting it. I don't want to be charged with contumacy because I'm not working with the court. Which, as I say, if you're being belligerent and you're being rebellious, and contumacy means that you're insubordinate.
So if you object too much, they might charge you.
They just charge you with it, right? Or if you don't plead. Okay, so after a while you get frustrated. So, okay, I'm going to plead not guilty. I'll take it to court. And if you find me guilty, then PCO 42.3 lists 6 different areas that a person can use on appeal. That's not an exhaustive list, but it really does cover the waterfront. And one of them is manifest prejudice or lack of following proper procedure, so that you can make that case afterwards, and so forth. Now, that's jumping way ahead, assuming that you're found guilty. But a faultily drawn indictment will definitely wound the case and probably cause a turnover, an overturning of the case. So a court is better served if they follow the rules. Remember, it's a level playing field. You've got stripes, 5 yard, 5 yard, 5 yard. You've got goalposts that are planted deep in the ground with cement. They're not movable. So follow the rules along the way, and you may get frustrated when somebody is raising a question, but it may be they are raising legitimate questions that you need to deal with. Okay? So that's the reason. So we start with evidence, not emotion. If there is a strong presumption based on that evidence, remember you have a high probability of gaining a guilty verdict. The issue should go to trial. Then a prosecutor that's familiar with the matter puts in the right order charges with the following, with the specifications to demonstrate that charge, and however many charges there are, you would do it with the witnesses, and then you would send that indictment, which is signed by the moderator or the clerk, along with a citation requiring the member to show up on such a date to enter a plea. And all that can be done at that next meeting to answer that citation is to enter a plea. It's not a time to negotiate anything else.
Now, let's assume the charged person was either found no strong presumption of guilt or was tried and found not guilty. Do we have a double jeopardy doctrine in the PCA?
There's not in there. We assume it because it's so strong in our culture. But it's not in our book. But I would argue that if you did make a case the first time, then you can't. It would probably be difficult to make it the second time. And it could even be seen, and again, it goes back to that personal, the closer a court is and the members of the court are to the circumstance, the more personal it is, that they may be seen as now biased and intimidating, trying to get at the person in any way they can. And that's not the reason for judicial process. I had a case where we had a person who was accused by one person of a woman accused a man of that they had an affair, and the emotional perspective, because of the way the woman was so overwrought, seemed like she must be right. Do you have anybody who can verify with you? Because the man was denying it. Did you go to a motel? Did you get receipts or anything? She didn't. She even tried to make a recording, but it was garbled and it didn't come across. And so my advice was, it's a he said, she said. Now, you may feel it.
No two witnesses.
That's right. You may feel it, you may sense it, but you cannot prosecute that.
No rape case or anything, no rape kit or anything.
Nothing. Right. And it
would
was,
a rape kit? Would a
well,
rape
at
kit
that point, it wasn't rape. It was consensual. It was an affair. It was going on for a while, and the gal now was feeling guilty. The woman was feeling guilty, and so she came and was confessing that this, and the pastor was using, his authority in such a way that was not very good. But nobody else and nothing else was there to be able to validate for the purposes of court. Now, on a personal level, now we go back to the pastoral. You could sit down with the man and say, now, we don't know whether this is true or not. This woman really does believe it, and the way she presents herself, we tend to want to believe her just because it doesn't seem to be any other mitigating circumstance of a jilted lover or something like that, whatever the case may be. And so, brother, we're going to challenge you pastorally to look into your heart and look into your conscience.
And watch your conduct.
And what, right,
Don't
exactly.
appear guilty.
That's right.
Appearance of impropriety.
And even at that point, in this particular instance, that wasn't there either. You see. So I'm just saying that you fall back on that, and the hope is that if what she is alleging is true, but you don't have the evidence for it, you can still say to the guy, whether it's true or not, I don't know, but she thinks it is not. So you look deep in your heart, and you want to leave a fly in the ointment of his conscience, at least. Okay, that's pastoral. Okay, but
sure.
But so we're talking about judicial process here. But you can't. No matter what you may feel about something, don't use that as the measure of whether or not you're move something forward. There's one other thing when it comes to the prosecution of the matter is there are time limits on these. When a citation is signed by the clerk, it must be received by the person, and he has at least 10 days. You have to give him at least a minimum 10 days for him to respond and show. If he chooses, the member can file in writing, so that's okay.
Well, speaking of deadlines, the 1-year deadline applies from the event that happens,
Yes.
that constitutes the charge, up to the day of the indictment.
You're right, exactly. It has to be processed. Process and matters of scandal must be begin within a period of 1 year after the matter is the offense is committed.
And that's measured by the day of the indictment.
Yeah, it would be, yes. The 32, not when it's reported, when the indictment is filed, unless the matters become recently flagrant.
Recently flagrant, right?
Okay,
So
now that means
there's no limit on that, though.
Yeah, right. Except that if someone alleges something that took place a year ago, and then it doesn't happen again, so now we're getting to that 1 year period. The court, if you're going to file anything, has to be filed before that 1 year statute of limitation is over, unless something happens even there or even later, where a new 1 year clock ticks that is comparable to what took place before. It can't be a totally different kind of event. Okay, or action, let me put it that way. Okay, so you stole something, and then you never stole anything again. You didn't prosecute. Your 1 year statute of limitations is over. Now, but the next time you gave a line, told a big fat lie or something like that, well, that's a different issue than stealing. So the eighth commandment
But
here.
the flagrancy, becoming flagrant,
Yeah.
will let you go back to the original.
Then you can you can start a new 1 year clock, plus go back and pick up the other. Yes. Okay, that's an important thing. But otherwise, you can't sort of piece things together and show a pattern.
Multiple instances.
Unless you can show that things are being done in a timely manner. There's one case where these members I talked about, I said 4 members before, earlier on, they were gone 3 years from the church, when after the 3rd year, they reported to the presbytery something about their pastor. Well, they had not only been gone for 3 years, even if they hadn't left their membership, which they all had, let's say they all kept their membership on for whatever reason, they were still not present to observe, make any observation of what they were charging this man with over that for 3 years. And all of a sudden, they have this document that they present to the court to say, we allege this guy is doing all these things that were out of order as a pastor. And I said, no, you've lost your opportunity. Ramsey wrote a commentary on the Book of Church Order and has this statement. By the way, we're talking about BCO 3220 in the Book of Church Order, 3220, and it says, he uses a very interesting word that I've put into my vocabulary now, and that is that if you do not do something and you've known about it, especially the court, then you are debarred from ever going forward and doing and prosecuting the matter. You're debarred. I love that word, and that's true also of any potential witness. If you do know something, you have not done. Let's say there are 2 witnesses, but you haven't acted within 3 years, you're debarred from bringing out that allegation, especially since you haven't observed anything that could be considered comparable flagrancy, okay, because you've lost your opportunity. And the reason that Ramsey gives is beautiful. It's not to try and cut off justice. It's that justice demands that when the matter is known, it must be dealt with. And if there is delay in dealing with it, then the court loses because it delayed. Okay? So therefore you're debarred from the process any further. So whatever you do quickly and do rightly. But not quickly, because there is time. If it's serious, then you can give. And if somebody is really acting up in an inappropriate way, most likely it's a behavioral pattern. And if you report it correctly, get the evidence, and there will probably be a flagrancy that would be picked up again, most likely. If not, you deal with it expediently and contemporaneously.
Thank you, my friend.
Good.
Good to see you.